Welcome to Pyramid Parent Talk. I'm Karen Harper Royal.
And I'm Lynn Farlow.
We're parents with Pyramid Community Parent Resource Center, providing information and support to parents of children with special needs in New Orleans. At Pyramid Community Parent Resource Center, we provide one-to-one assistance, workshops on special education law, positive behavior support, and advocacy skills. You can reach us on the web at www.pyramidparentcenter.org, or follow us on Facebook at Pyramid Parent Center and on Twitter, Pyramid CPRC. Or you can call our helpline at 504-218-8922. You can listen to a repeat of this show and our previous shows at www.pyramidparenttalk.com. Today we're discussing the recent landmark consent decree regarding special education in public schools in New Orleans. Yesterday, federal court judge Jay Zainey of the Eastern District Court of Louisiana gave his final approval of the settlement of the lawsuit brought initially against former State Superintendent Paul Passerek in his role as State Superintendent, but now that we have a new Superintendent, John White, in his role, the Louisiana Department of Education, the Bessie Board, which is the Board of Elementary and Secondary Education, and the Orleans Parish School Board, which actually voluntarily joined the lawsuit as a defendant. On yesterday, Judge Zainey held a fairness hearing related to the consent decree. There were two objections discussed in this hearing. Actually, there were four people who filed objections, but actually two of them were in support, and then there were two objections that were discussed in the hearing. And as it turned out, it wasn't that people were objecting to the fact that there is a consent decree. There were two parents who didn't feel that the consent decree went far enough in addressing their specific issues. One of them wanted some monetary damages so that she could get ongoing support for her child to be taught at home, and because of some problems she felt were caused by the school system not doing what they needed to do for her child. And then the other parent really wanted help to get a school that was safe and one that nurtured her child's strengths. So basically, both parents wanted the consent decree to go even further than it does. And we think the consent decree does a great job of addressing some of the structural issues.
Karen, that second parent. Mm-hmm. So what exactly does she want?
She has concerns about the school that her child is at. She doesn't feel it's a safe place.
Okay,
so
safety.
She wants the consent decree to address getting a school that she felt was safe and nurturing. But that's a very individual issue, and it is important for us all to understand that this lawsuit was not about individual relief. Parents still retain their rights under the Individuals with Disabilities in Education Act, under Section 504 of the Rehabilitation Act, and under the Americans with Disabilities Act, so that they can just follow that regular complaint resolution process. This lawsuit was about getting policies in place that protect students with disabilities in a school system that looks like ours here in New Orleans. It hasn't always been very clear where responsibility lied for issues like child fine, which means that school districts have a responsibility to actively search for children with disabilities. Each of the recovery school district charter schools are in effect their own school district, so it became very confusing as to who held responsibility for that. So this consent decree will help address some of those issues. We know that parents find themselves going in circles when they have children who are out of school due to discipline-related issues. And, that's what we're going to talk in detail about today. And then there were some problems with enrollment where parents have been turned away from some schools. The consent decree definitely addresses that. And, we covered that last week.
So
last show.
And parents, if they want to hear that, they can go to www.pyramidparenttalk.com to hear that show.
Yes, and this lawsuit and the consent decree, it addresses some of the structural issues because of the kind of system we have. And now it focuses on the steps that the Orleans Parish School Board, the Louisiana Department of Education, and individual schools will have to do to make sure that some of those structural issues created by the kind of landscape of schools we have here don't become a way of denying a free and appropriate public education to children with disabilities. So this means that since there were no real expressed objections, especially from schools, that would cause the judge not to approve it, the consent decree, after a few technical things some of the lawyers have to do, the consent decree is for all practical purposes approved and will go into effect. If you'd like to join our discussion today, give us a call at 504-260-9265.
All right. We're excited that the consent decree didn't have any objections, so that's very good for our parents that we served. Like Karen said, this is our third show on the consent decree. Our first show on the subject gave an overview of what the consent decree is. And we know this is a lot to take in, so we wanted to break down the different sections of the consent decree to make sure our families are clear on what they can expect and what's different, what is different with this consent decree and things that they wouldn't see in school or they haven't been seeing in school. Our second show focused on enrollment, and that was done purposefully because we just had the Urban League School Expo this past weekend, and we wanted parents to have information about the enrollment of children with disabilities before the expo. So hopefully that information that parents got was very helpful. Today we're going to talk about the discipline section of the consent decree. So again, if you want to join the discussion, please call us at 504-260-9265. So, Karen, what does the consent decree say about the changes to discipline?
Well, Lynn, as you know, we get a lot of calls from parents, most often about discipline issues. In fact, recently, the Recovery School District released some data saying that expulsions are down in the Recovery School District. But we know many of our parents have seen their kids sent home without being officially expelled. And the consent decree is going to help in this area of discipline because there will be more monitoring and technical assistance as this consent decree is implemented. In fact, within 60 days of the implementation of the consent decree, the Louisiana Department of Education, the Orleans Parish School Board, will review the student code of conduct or the discipline policies at each of their schools. And in reviewing this, they're going to be looking specifically to see that these discipline policies are in line with what the IDEA says.
Okay.
And if this policy changes, these schools are going to have to let the state know that it has changed. They're going to have a written description of the disciplinaries, procedural protections, and procedural safeguards for students with disabilities. And I've seen some of these school discipline codes, and they don't even mention the things such as needing a manifestation determination. Like, how would a parent know when they should have received this manifestation determination? That's something that is within the procedural safeguards of the Individuals with Disabilities in Education Act.
Karen, and I think it's a good idea to mention to families that on their own they can look at the discipline policies under IDEA so that they can then compare it to their discipline policy that they get from school.
Yes, you're absolutely right. Parents, at Pyramid, we say if you don't know your rights, you don't have any. So it is very important that you, too, study the special education law. I usually go to a website called Rights Law, WRIGHTSLAW.com. Rights Law puts out a really good book about the Individuals with Disabilities in Education Act. But you can simply Google the Individuals with Disabilities in Education Act and get access to the what it says.
Right. And they could go further and put in discipline with the with IDEA.
Right.
IDEA and discipline, and then you can get right to it.
Right. As much as I am excited about this consent decree, it still requires that we as parents be on our game and making sure. I mean, just before I came here to the radio station, I was on the phone with a parent who had told me about a suspension her child had received. And on the paperwork it said 1 day, but they told her to keep her child home for 3 days.
Right.
So, this consent decree, we'll talk about it a little bit further. One of the things they're going to have to do is go in and monitor the paperwork to make sure the paperwork says the right thing, because we know that in special ed, if you can't suspend the child for more than 10 days without doing some other things. Some people have the impression that you can't suspend a child with a special needs child for more than 10 days. Actually, you can. But there are some other things that you're supposed to do, such as the manifestation determination review to see if that child's behavior was related to his disability. You're supposed to do a review and a revision of the behavior intervention plan and make some changes in the IEP if that is necessary. So it's important for parents to be keeping track of what's on the paper and how many days your child is actually home due to behavior.
Well, Karran, let's with this parent who was suspended for 1 day, but they told her to keep the child home for 3 days. What should that parent do?
Well, as of right now today, I would recommend that parent file a complaint against that school for violating her child's rights, but also for not following what the law says they should follow. It's possible that this particular situation, they should have done manifestation determination. The paperwork did not even have the parent's right to appeal on it, which is also a problem. So due to some of the combination of all of these problems, I think that the parent should file a complaint so that the state could look at this. Now, when the consent decree goes into effect and we have the independent monitor, this is certainly the kind of thing we want parents to report to the independent monitor. Also, parents can contact the Southern Poverty Law Center at their hotline that they just started, which is 1-844-687-3958. Again, that's 1-844-687-3958. And just make sure you let the Southern Poverty Law Center know that you want to be notified about this independent monitor so that you can make sure you know how to reach that person, whoever it's going to be, because they're going to be looking at paperwork. But paperwork doesn't always tell the full story. Just as the Recovery School District is talking about the reductions in suspensions, we know that there are children sitting at home right now today without any paperwork that says that they are suspended or expelled. So, we need parents to have their eyes open. So the schools are going to have a written description of how they're going to comply with the law. But also, the schools are going to have a plan for supporting school behavior and discipline that is in compliance with what we call the Bessie Model Master Discipline Plan, which includes things like positive behavior support interventions, interacting with the different mental health agencies. I know that I did work several years ago on making sure all charter schools had to follow that law, just like traditional schools. So the independent monitor is going to be looking to make sure that these schools are definitely in compliance with that part of the law. So, again, parents, please step up your game to make sure that these things are followed. Each school district, each school is going to have to submit written assurance that the code of conduct is in compliance, and it hasn't changed since the state last reviewed it. One of the other things that these schools are going to have to do, and the state's going to have to do, is provide technical assistance. That's like professional development for your school, helping them to know that it is prohibited to do these undocumented suspensions. So we know it's illegal. We know they're not supposed to do it. But they're now going to be trained in that. So there's going to be no excuse for anybody at the school sitting a child home without paperwork. Now, one of the things I hope happens after this, if we find that there are some schools doing this, that means they are really violating the law. It is really time for the Louisiana Department of Education to make some examples of some of these schools. Charters can be revoked if you violate state, local, or federal laws. So now we are all clear. These schools will get the technical assistance where we're making sure they understand they can't do this. So if they turn around and do this, they deserve to have their charter revoked. That's just my opinion.
And again, we need to stress to families that if any of these things are happening to their children, that they need to report it.
So under this consent decree, that technical assistance is going to have to be provided every year while the consent decree is in effect, where schools are going to have to teach their staff, and the independent monitor is going to review what this technical assistance looks like, what these professional development activities are. The independent monitor is going to review the materials that are going to be shared with schools. So this is really serious, in that there's going to be, multiple sets of eyes on this.
Is there a set time for the consent, for the monitoring to go on?
Well, the monitor, hopefully that person will be hired by the end of March. So the monitoring will go on for the 2-year period of the consent decree. Now, the consent decree will be in place until there is substantial compliance with all parts of this, where all parties are substantially compliant with this. So it is possible that this consent decree could go on beyond the 2 years, and the monitor could be in place beyond the 2 years. Okay? So the next thing that's going to be going on with this consent decree around discipline is that the state is going to each year calculate the rate at which each school district in New Orleans removes students with disabilities for disciplinary purposes for more than 10 days. And as they calculate that, the state is then going to select, I believe it's up to 10 of the LEAs for targeted monitoring. That means they're going to, go in and take a look at their paperwork, a representative sample of the students with disabilities who receive 6 or more discipline referrals. So it's not just looking to see if you have those suspensions in place, but if there are 6 or more discipline referrals or 3 or more suspensions in or out of school. And that's important, because a lot of times people don't look at in-school suspensions as suspensions. But think about it this way. If you are in an in-school suspension, then you're not in the classroom getting instruction, which is a violation of your IEP if that happens too often, more than those 10 days. So they're going to go in, with this targeted monitoring, looking at the paperwork at these schools, looking at those discipline referrals. And they're going to do interviews with the staff. They're going to do site visits. And there's a whole part of, when you look up this consent decree on the State Department of Education's website, there's something called Addendum A. And so in Addendum A, it lists the protocol for the review of the student files when they go into the schools. They're going to be looking to see if the school district or the school notified the parent on the same day as the date of the removal. They're going to look to see if the IEP team considered relevant information about the student's file, including the student's IEP. They're going to be looking to see if the behavior was or was not a manifestation of the disability. They're going to look to see if there was a functional behavior assessment. There are many, many things that they're going to look to see if are in place. So it is very important that parents know what their rights are, because I'm sure we have parents who don't know that there's anything called a functional behavior assessment that should have been done. if their child had been removed for more than 10 days. So those are some of the things that they're going to be looking at as they go in and do this paperwork review.
And if we have parents and families that need to know more about the law itself, especially around discipline, and they want us to go into it, then they need to call us.
Yeah, they can. Yeah, let's go on and repeat our helpline number.
So our helpline number is 504-218-8922.
Because we can design a workshop specifically for parents that would help them to relate what they're going through to what's going to be coming down the pipe as it relates to this consent decree. We do one-on-one assistance. That's some of that one-on-one assistance and workshops to help you understand your rights. So we can definitely do that for parents.
And I'm curious. We would like to hear from parents if they experienced anything while they were at the expo with schools saying, we can't service your child at our school, or, you should try another school. That would be interesting. Yeah,
so give us a call here at the radio station, 504-260-9265. If you were at the Urban League Expo this weekend, and as you talked to the different schools, did you feel that they were kind of discouraging you from applying? Or were they open and explaining to you the kinds of services they provide at their school? Because last week when we talked about enrollment, we went through the fact that the schools are going to have a written description available at the school site, on their website, and staff's going to have to be knowledgeable about the kinds of services that that school will provide for a child with a disability. So the next thing is we said this before, none of what's in this consent decree means that you don't have the right to use the regular protocol. And school districts normally do monitoring of paperwork, or the state normally does some amount of monitoring of paperwork. And this doesn't mean that they're not going to do that monitoring of the paperwork also that they normally would do under the law. All those things will continue to happen, even though they're going to be taking a look at just a selection of the schools. If parents are making complaints to that independent monitor about several schools, it is possible that they can do targeted monitoring of even more than that selection, which I understood to be, I don't know, somebody must have told me it's going to be about 10 schools. But if one school keeps coming up over and over again, then the monitor can do more looking into even more schools.
So the monitor has, of course, that kind of leeway.
Absolutely. And that's why it is just so important that parents know who the monitor is. Once that monitor is hired, I'm sure there's going to be some kind of meeting to help make sure that you can get information about how to contact the monitor. And again, don't forget, the Southern Poverty Law Center will still be involved in this because they've set up that hotline. And we'll repeat that hotline right before we go off the air in a few minutes.
So, once again, parents should be looking out for, in regards to discipline, being expelled, well, not expelled, but getting too many suspensions, going past the 10-day mark with suspensions. They should be keeping up with what's going on with their in-school suspensions if there's too much of that going on.
The mama come pick up your child.
And right, which we're all too familiar with that, because really that's something that they should not be doing. And we could go further into that if you give us a call about many of the reasons why they shouldn't call you and say, come pick up your child.
Right.
If you make sure you're keeping up with your the number of suspensions that you have, so that you
can removals.
Yes, and so you can report it to the monitor.
One thing I want to also say: if your child is always being sent to the timeout room or whatever your school calls this other little room.
Mm-hmm.
It's not an in-school suspension, but it's just we're going to send, Johnny to this other room. They'll keep track of that stuff too.
So the alert really should be all that undocumented stuff.
Absolutely. Absolutely. And again, you can get your copy of this consent decree if you go to www.louisianabelieves.com. Then under the Hot Topics section, click Settlement Notice. And that's going to take you to the joint statement, and then click Settlement at the end of the paragraph. Because we want you to have a copy of this consent decree so that you can be a part of making sure that it is implemented properly and your child is served properly. Once the Federal Monitor is on board, you can report your concerns to that monitor. Also, you can call the Southern Poverty Law Center's hotline at 1-844-687-3958. And of course, you could always call us here at Pyramid 504-218-8922.
So our next show is Tuesday, February 24th. Also, if you have any concerns regarding your child with a disability, contact us at our helpline that Karen just mentioned, 504-218-8922. Remember to follow us on Twitter at Pyramid CPRC and like us on Facebook at Pyramid Community Parent Resource Center. And you also can hear a rebroadcast of this show at www.pyramidparenttalk.com. And remember, you are never alone.